Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I'm Kimberley Robidoux, partner in San Diego, and I'm joined today with Miki Matrician, our co-managing partner of the Boston office. So good to see you today, Miki.
Hi, Kim. How are you?
Good, I'm doing great. The past week has been interesting with the administration announcing so many different changes to immigration as we know it. So today will be true rapid fire as we touch on each of the announcements that impact employers and employees. They also have an impact on immigration strategies that will be enlisted by global mobility and HR professionals. So, what are we going to discuss today? Well, we're going to talk about the proposed gold card, a new alien registration requirement, increase in I-9 audits, revocation of the work authorization for Hong Kong DED, and a U.S. Department of Justice memo that directs federal prosecutors to prioritize immigration related cases, which could affect many employers. All right, Mickey, let's get started with the gold card. Can you tell us about this proposal?
Yeah, so last week, Trump had proposed a Trump Gold Card plan. And these are some of the basically the key features that distinguish that proposal from the current EB-5 Immigrant Investor Program. So the proposed plan has an investment amount of $5 million paid directly to the US government to reduce the national debt. And, in contrast, the EB-5 Immigrant Investor Program requires a minimum of $1.05 million investment in a U.S. business or $800,000 in targeted employment areas in order to stimulate the U.S. economy through job creation and capital investment. The proposed Gold Card program doesn't have any requirement to create or preserve jobs, while the EB-5 program really does require the investor to create or preserve at least 10 full-time jobs for U.S. workers. In addition, the proposed Gold Card program provides a pathway to citizenship. There's no additional information provided about this just yet. The EB-5 program grants eligibility for permanent resident status with the potential for citizenship after meeting job creation and residency requirements. We also have information to share about some tax implications. Specifically, the proposed Gold Card program would require holders to pay U.S. taxes on income derived in the U.S. while generating income outside the United States wouldn't be taxed. So the EB-5 program subjects permanent residents to U.S. taxation on worldwide income upon getting the green card. And then finally, the proposed program was just announced at the end of February 2025 with a lot of details yet to be released. Essentially, this isn't something that the president can create with a stroke of a pen. Congress would need to enact legislation to roll this program out. And just to plug that for the EB-5 program, which was established in 1990, and regional center program under current law is not expiring until September 30th, 2027. Our partner Joey Barnett spoke about this during the EB-5 Chatting with Charlie program on February 27th, 2025.
All right, that's great analysis, Mickey. And it is a lot of information to unpack, and we need to keep moving, right? There's so much more on our agenda. So let's go on to our second topic. And can you tell us about the announcement of an alien registration requirement, and what is it, and what does it mean for foreign nationals in the U.S.?
Yeah, so the alien registration requirement was announced on February 25th by USCIS and is basically a result of the January 20th executive order protecting the American people against invasion, which directs the Department of Homeland Security to enforce registration requirements under the Immigration and Nationality Act. So it's a new process that would require individuals to create a USCIS online account with a new form that will need to be filled out and a new process to be completed by non-citizens that are staying in the U.S. for 30 days or longer. And so non-U.S. citizens would need to be fingerprinted and registered unless they've already been registered through the existing immigration process. So the non-U.S. citizens include permanent residents, I-94 recipients, individuals in removal proceedings, and EAD holders. Some individuals that may not already be registered include undocumented individuals, certain Canadian visitors, as well as some DACA and TPS applicants. And so basically under this new system, the failure to comply with the registration process may result in civil and or criminal penalties. So we're waiting for additional details to be announced by USCIS about this registration process. So these are two of the biggest announcements regarding immigration that happened last week. Kim, how about I-9 audits? Any updates there?
Yeah, so about mid-February, we started to see an uptick in I-9 audits, which means that Immigration and Customs Enforcement, Homeland Security investigations auditors and agents have been issuing those I-9 notices of inspection to employers. So with the NOI, which is a notice of inspection, employers have 3 business days to provide the requested forms I-9 to Homeland Security investigations. And then HSI may also ask for additional documentation, which may be required to be provided within 3 business days. But in many instances, HSI will permit an employer to have more time to gather those documents and provide them to the auditor. And those documents are typically the business license, the payroll reports, information about e-verify programs or social security no match letters. So the additional documentation, it takes a little bit more time to pull together. So the I-9 audits have been occurring throughout the US and have focused, based on what we're seeing, on manufacturing, hospitality, retail, construction, staffing, and janitorial industries. So, given the increased I-9 audits, the best action that global mobility and HR professionals can take to prepare is to conduct a review to make sure that there are I-9s for every employee hired after November 6, 1986, which is when the I-9 form came into existence. And then also, they should make sure that if an electronic I-9 system is being used, the company rep should know who to speak to in order to obtain the additional reports, such as audit trails, et cetera, that are going to be required to respond timely to the I-9 audit.
Thanks, Kim. Yeah. And previously in Rapid Fire Wednesday, we talked about the changes to the work authorization expiration dates for Haiti and Venezuela TPS holders. There's another program that has been impacted as well. Can you give us an update?
Yeah, sure. So that program is the Hong Kong Deferred Enforced Departure, which is referred to as DED. And the Biden administration on January 15th of this year extended the DED for certain Hong Kong residents and also directed the Department of Homeland Security, essentially USCIS, to extend the work authorization of those individuals until February 5th of 2027, so a 2-year extension. However, on February 18th, USCIS issued revised guidance and stated that the DED related EADs have not been extended. So the work authorization for these Hong Kong DED recipients has ended, and as such, those individuals may not continue to work using the Hong Kong DED employment authorization document. So employers really need to re-verify the work authorization of these employees as they normally would do in order to determine if they can continue to work based on some other type of work authorized status. And okay, Mickey, one last topic for today's Rapid Fire Wednesday. And that is the Attorney General issued a memo to the US Department of Justice that's called General Policy Regarding Charging, Plea Negotiations, and Sentencing, which doesn't sound like it really pertains to immigration, but it does. So, can you please explain to us what this means for global mobility and HR professionals?
Sure. So this memo directs federal prosecutors to prioritize immigration related cases, which could affect many employers. It means that companies could potentially face criminal charges in cases that Department of Justice may not have pursued in the past, including for employing undocumented immigrants. So to justify this priority, the Attorney General basically said that the nation faces historical threats from widespread illegal immigration, and that because of that, immigration enforcement is at the top of the prosecution priorities. So, if an employer employs undocumented immigrants, it's possible, depending on the circumstances, that the government could equate this to harboring aliens, which is a provision that hasn't really been used much in the past. And it looks like the Department of Justice may pursue criminal charges against companies and individuals who know or recklessly disregard the fact that somebody is unlawfully present for transporting, sheltering, or even employing such individuals. So, this could be used also against employers who knowingly or recklessly utilize outside staffing agencies and or contractors that participate in that type of conduct. So The enforcement of the priorities on this memo also means that there will be more FDNS site visits. And failure to comply with the site visit might mean a revocation of the H-1B petition or worse. So while the H-1B cases may be referred for revocation, which has been the action taken normally in the past, it's possible that FDNS may refer these cases to DOJ and other entities for possible criminal investigations.
Yeah, so that's a lot. Very change in priorities, what we've seen in the past. So I guess that's a wrap for today's session with all of the topics that kind of came about, within the last week or so. So stay tuned for future episodes on updates to the immigration landscape. If you don't already, please follow us on our LinkedIn page for WR Immigration, as well as Miki and my individual profiles. And we also transcribe Rapid Fire Wednesday into a weekly newsletter that you can subscribe to. Good to see you, Mickey.
Good to see you, Kim.